Hello, everyone. Welcome to another episode of the Unresolved Question. This is a special judicial episode of the Unresolved Question. And today my guest is Honorable Mr. Justice Paul Perell of Ontario Superior Court. Good morning, Justice Perell.
Good morning, sir.
It's really great to have you. I think everybody who is watching this knows you. You are definitely well known. Mr. Justice Myers described you in an interview that he gave on the show as a judge whose decisions should be studied by lawyers who want to know the law on a particular issue. I asked him about different ways that lawyers can stay abreast of the law, and he said, just go find the decisions by Mr. Justice Perell. You are on the class actions list. You produce a tremendous volume of decisions and other work product, if I may put it this way. But what I want to start with is your origins. I'm sure the audience is really curious how you landed where you are, where you come from. So let's start with where you were born.
Well, I was born in Hamilton, Ontario in 1949.
Okay. Well, that's a very good place to be born, as good as any. It's very close to Toronto. Tell us about your parents. Did your parents send you off on this path to becoming a judge, to becoming a lawyer? What role did they play in your life?
Well, my dad served in the Canadian Air Force in the Second World War. And he came back from overseas, and he married my mother in 1947, and I was born in 1949. My mother and father worked together in a paint store in Hamilton, Ontario throughout the whole life. So I had a working mom. In relatively short order, she had 3 children, me and my 2 sisters. We moved to Burlington when I was in grade 3 to Aldershot, Burlington. We sort of had a middle class existence. We lived with my grandmother, who was originally from Russia, but the Ukraine part of Russia. My mother and father were first generation Canadians, and we lived with my grandmother and my mother's brother, my uncle. So there were 7 of us. I went to high school at Aldershot High School, decided that I wanted to go away to school, spent a year at York University, transferred to the University of Toronto, where I was a major in English. I was reading a Dryden poem one night and decided that that was enough of that. I did the LSATs, went to Osgoode Law School, graduated, went to Weir and Folds, where I was in the litigation side of the firm, and then became a partner. And at the time, there was beginning a vogue in Toronto that had been started by Justice Bertha Wilson to have research departments. I was in the litigation department. I thought Weir and Folds should follow. And I was always academically interested. So I became their research director, which was really part of the litigation side of the firm. And then, at some point or other, in the 1980s, I enrolled in the full-time master's program while I was working at Weir and Folds. So I was doing 2 things. don't think I told them that I was doing that. So I got my master's degree, and then 10 years thereafter, I did the same thing with a PhD at York. I didn't tell anyone. I didn't tell anyone except my family that I was doing a PhD. Then I got my PhD. I phoned my Jewish mother and said, "You wanted a doctor. You now have a doctor." And that's the history.
That's a fabulous story. When I was in Osgood, and I was there from 2007 to 2010, you taught real estate transactions. In fact, I think you taught real estate transactions at Osgood since 1991, because I remember seeing a website, Osgood Hall Law School website, that had your bio because you were appointed to the court. So they had a press release or something about that.
Well,
Go ahead.
Just on that, I taught at Osgood for I can't remember, but for approximately 20 years before I was appointed, and for a period after I was appointed. I also, at the beginning, I taught both semesters at Osgood. So I taught a lot of people. I began teaching one semester at Osgood and one semester at U of T. So I taught at both schools for a period of time. So probably, I can't remember exactly, probably taught about 10 years at U of T at the same time as I was teaching at Osgood. And then after, there was a few years after I got appointed, I stopped doing both.
And of course, you taught real estate, and you are known and were known as a real estate expert. You told me that you practiced in the litigation department and you founded the research department. How did you become a real estate expert, a real estate transaction expert?
Well, I actually never was a real estate transaction expert. The only transactional work I did in real estate was when I was an articling student. I got sent to Cornwall to close part of a very large plaza real estate transaction. And I have to say, for 6 years, I sweated the limitation period out because I didn't know at all what I was doing. The reason I got into, I have a reputation in real estate and I ended up teaching real estate is I had been doing a lot of continuing legal education and writing papers and doing attendances at the Canadian Bar Association, Ontario, and for the Law Society. And an editor from Butterworth's at the time by the name of Paul Truster, who went on to do legal education work for a variety of organizations, contacted me and suggested that I do a book about mortgages. I wasn't particularly interested in doing a book about mortgages, but I thought that it would be useful for my job at Weir & Folds to do a book about real estate remedies. Mm-hmm. And in the context of doing a book about real estate remedies, you had to learn the transactional side of real estate transactions. But I actually never did that work. And then I wrote the book, and then I applied to be an ad hoc faculty at Osgood to teach that, and then that's how I got a reputation in real estate.
Interesting. Do you miss teaching? You don't teach anymore. You haven't taught in years. Or do you still teach every once in a while somewhere?
Well, I occasionally do some legal education, and I have been for a long time on the Superior Court's Education Committee. Um, the Do I miss teaching? I like the teaching very much. I hated the exam marking at both schools. It's quite oppressive, and it was something that was a bit too much to manage while I had my judicial career. And it's not so, it just became a bit too much to do the teaching. I was typically, what I was doing when I was teaching the courses is I'd have a regular working day, and then go to either Osgoode or U of T by subway, and teach from 7 o'clock to 10 o'clock. That's a very long day.
Yes.
So I may go back to it, but I did stop.
By the way, I want to thank quite a few lawyers who contributed questions to this interview. A lot of people expressed interest, and I polled quite a few lawyers, and I thank them for some of the questions that I'm asking here today. Well, you explained how you entered the real estate field, how you acquired the real estate reputation. We now know you as a class actions judge. Can you tell us the same story about class actions? How did you enter that field, and how did you acquire your reputation in the class actions field?
Well, the normal sort of rotation when you become a new judge in Toronto is that you're rotated through a variety of lines of service. One of them is civil, one of them is criminal, one of them is family, one of them is divisional court, another one is class actions, one of them is the commercial court. I had begun my career, and I'd done a civil rotation, and then I did a family rotation. The next sort of rotation would have been to probably criminal. But Alex Hoy, who was doing class actions, she rotated off class actions and went to a commercial court. And they were looking for someone to do class actions. And the sort of understanding is that if you do class actions, you're sort of locked in for a couple of years, at least 2, perhaps more. So I volunteered to do class actions because I was interested in it. I had a major background with respect to civil procedure, because I had been on the Rules Secretariat, which was the research arm for the Civil Rules Committee, along with Gary Watson and Justice Craig Perkins and John Tuig from the ministry. And we've been working for years and years and years. Class actions are really just a major aspect of civil procedure. So the class actions as a spot is not the easiest one to fill. And anyway, I was picked to do class actions in, I think this was in 2007 or 8. And then what happened is I never left, is what happened.
I see. I see. And they never kicked you out. So obviously you're good, right? So I'm sure that a lot of parties and lawyers are very happy that you're on the class action list. And I know that quite a few lawyers who practice class actions are anxious to know some of your opinions about class actions law. You did mention just now that in your view, class actions is really an aspect of civil procedure. However, I have a question from someone, the following question. In your view, what is the most consequential unresolved issue in class actions law? Is it constitutionality of the national or international class, Section 25 procedure, the nebulousness of the uncertified or post-trial class, or just predominance and superiority? And I'm just quoting the question. I'm not a class actions expert.
Well, I think one of the interesting things about class actions is as an area is that it is a continuing to be developing area, and it morphs and changes. I don't know that there is, per se, an unresolved issue. There are issues that develop. Some of the issues have a tendency to pendulum a bit and move back and forth and change. I think there's some major work that needs to be done with respect to the individual issues part of the of the class action proceeding. I think the amendments to the act need to be shaken out, and there will be some changes perhaps there. The other aspect of class actions work that makes it interesting is it's an area of law in which substantive law develops, and so there's lots of interesting areas of substantive law that are connected to the class actions group. For instance, in the securities area and in the competition area and in the tort area and the consumer protection area, where as interesting as the class action side is, the substantive law side is, particularly with respect to new torts and a variety of things like that. So it's very interesting work, and it's certainly not static.
I'm wondering if you actually, so I'm going to ask you a question about class actions. My next question, I'm wondering if you actually answered it when you said that class actions, in your view, are an aspect of civil procedure, and also when you contrasted class actions effectively with substantive law. So the next question is, do you think class proceedings can and should serve a regulatory function? If not, why not?
Well, I think the answer to the question is not whether they can. The answer to the question is that they do. Class actions are a aspect of civil procedure, but they actually can be further classified as public law. And they have seen a clawback, really, of the jurisdiction that the court had, but lost to a variety of administrative tribunals. I mean, the public law pulled things like the regulation of securities and sent it to the Securities Commission. Public law pulled competition and sent it to the competition tribunal. Public law pulled labor relations and sent it to under the Employment Standards Act to government regulators and a variety of things. Well, class actions have got the court back into being a player in those areas of law. So the answer is
Consumer
not
protection
whether,
as well. Yeah.
yeah, exactly. And so the question is not whether it can, it is.
Mhm. Do you do anything that's not class actions? And if yes, what percentage of your time does it occupy?
Well, there was a period of time where, well, there's still a period of time where I do some sort of freelancing. I used to occasionally drop in and do some family law. I haven't done that in a long time. But from time to time, I will fill a chair for the divisional court when they need someone. I do a lot of long motions in civil procedure and civil matters. I a long time ago I did a few attendances in commercial court, but they have been relatively rare. Similarly, with respect to estates, which is developing. There's a new estates team being developed, which I think is a good thing. And I occasionally would drop in and do that. In terms of percentages, it varies, but I would say that it's probably almost 50-50 in terms of doing class action work and doing long motions work in just about anything you'd want to mention.
Do you think you will ever grow tired or bored of class actions and the desire to do something else and switch, or is it the only love now, the final love sort of that you want to be with forever?
Well, the question is a bit academic in the sense that I'm in my penultimate year as a judge, and I could retire at any time. My mandatory retirement is in 2024. It's a bit late to go back and do the criminal law rotation, which, save for a couple of summary conviction appeals, I never did. I like the class action work. I like the long motions work. I like the occasional visits to the divisional court. I've also done occasional estates case or a commercial law case. So I'm quite happy with the selection of work that I have. And so it's not likely going to change in the foreseeable future.
You talked about the research department at Ware Falls, and you talked about your interest in academic pursuits and research. Over the years, that background as a research lawyer, how has it shaped you as a judge, or has it affected you as a judge?
Well, I think it's at the core of what I do as a judge. I was I went to a firm that had a reputation of being lawyers. Practicing law is about the law, I think, and I love the notion of developing the law and writing about the law. And so, as I say, at the time, there was this development in Toronto where the large firms, Weir & Folds was a medium-sized firm, but the firms were developing research departments. I loved the writing. I'd done a lot of legal research as an articling student and liked it. And that and some curiosity led me to being a legal research lawyer. But it was part of the litigation department. I aided the partners at Weir & Folds with respect to developing cases and a variety of things like that. That and the teaching, I think, was an excellent background. That and the work with the Civil Rules Committee was an excellent background to be a judge.
I want to ask you a pretty big question, but I want to build up to that question first. So you talked about your love for writing, and of course you are known for your long reasons. Justice Meyer said, if you want to know the law, go read Justice Perell's decisions. There are two questions here that come up. Number one, what do you read to find out what the law is? How do you keep yourself updated about the law? If Justice Myers recommends that lawyers read your decisions, what does Justice Perell read to keep updated about the law?
Well, you read an awful lot of law doing class actions and long motions. So it's not that you necessarily have to go looking for the law. I have been a legal author for a long time, and writing the book about real estate led to me reading a lot of law. I have my book, Ontario, Civil Procedure book, which it's in the 5th edition. Well, I'm working on the 5th edition, so I work on it from time to time. I sometimes borrow the work that I'm doing on a case and use it to update the book, but I, read a lot of cases from time to time to update the book, and that gives me an insight in the law. And from time to time, I still continued writing the odd piece about, the law, about something or other that might interest me. So I read a lot of law, actually, and write a lot of law.
And when you say you read a lot of law, you also read, because you do class actions. You said I do class actions, and that's why I read a lot of law. Do you also mean you read a lot of factums? And is this a source of information about the law that you use? Is counsel factums?
Yeah, the answer is yes, that's true. And they provide, huge, authorities case books containing a variety of law, and class actions in a variety of areas tend to be cutting edge. Right. So you get a good dose of what the current law is. But I don't subscribe to some sort of service or anything like that. It's much more ad hoc.
How many books behind you are law books?
Well, a lot, but not they wouldn't be in the majority.
Mhm.
There would be all kinds of other books that are behind me, a variety of sorts. There's quite a few books of law, but there are also quite a few books about topics that might be relevant to the law, and there's quite a few books that have nothing whatsoever to do with the law, or are about different things, but
Right.
lots of.
So another question related to this that somebody asked is, how do you manage your time to write your detailed and careful reasons so quickly? You said earlier in the interview that you love writing. Do you have a secret writing technique?
Well, don't know that I have any secret writing technique. I have spent, in terms of sort of, if you will, extracurricular reading, I spent a great deal of time reading about writing at one point in my career, both in terms of books about legal writing, but also a great deal of books about grammar and composition and syntax and rhetoric and a variety of different things. The explanation to answer your question is I work a lot. So it's not, and I guess the other answer is that I am relatively well organized, and I've kept most everything that I've written. So I have taken up the practice of, whenever I do a topic, to try and do more than the topic necessarily requires, or the subject requires at the time, because I think I'm likely going to come back to it. And so I have a lot of material, and that speeds things along. I mean, I think if you start to read, say, my class action judgments, you'll see a lot of repetitive material that goes in, and when I get an area, I will work it up, particularly if I work it up the first time. So when I got cases with respect to, say, the government's forfeiture legislation, when I got that first case, I did more than was necessary to understand that first case. And so when I got the second one, I would, build up the material. And so that speeds things along, but there's a lot of work.
I'm in awe of you, if I may say so. I'm just absorbing and taking all of this in. This is really incredible. I want to ask my big question now. Two words have dominated our conversation so far, and these words are write and read. Our legal system is based on the written tradition. It's unlike some legal systems that are maybe based on oral tradition. Our legal system is based on written tradition. We depend on writing things down, or we depend on writing the law down, because this is how, in our legal tradition, the law is communicated to parties, to counsel, to judges, and you talked extensively about this process today. We also, of course, because the flip side of writing is reading, we also depend on reading the law. So this matter of record the record of the law is really important to us, and it's central to the concept of legal research. And legal research, of course, is central to the concept of practice of law, because that's how we find out what the law is. My question is about the limits of legal research. And specifically, I want to ask you about the exceptions to the written tradition. Do we have such exceptions to the written tradition in our legal system? Are some things unwritten? And is this why traditionally lawyers could not rely only on legal research, but also depended on experienced mentors who would pass down these unwritten bits? For example, it seems, and I think many lawyers will sort of commiserate here, that there are principles that cannot readily be ascertained from case law. Of course, we are now seeing some efforts to conduct statistical studies of, let's say, motion outcomes. That is a completely different approach, very different approach from legal research, but it does not lend itself to factum writing. So we cannot necessarily or easily cite statistical studies in factums. Maybe some of my friends know how to do it, but I haven't seen that. Also, I think that there are some sort of myths or talk among lawyers that there are judicial attitudes to certain things that are not written. So there is a test on one hand that you find out from the legal research, but then there is also this judicial attitude. So for example, for some examples of these judicial attitudes, I will just mention a few, and I may be completely wrong, but these are only illustrations. So for example, fraudsters always lose on Mariva motions, regardless of dissipation risk. Our system doesn't like fraudsters. Or narratives beat tests, or cases where parties are self-represented are less persuasive. It's not written down anywhere, but if you ask lawyers, they will probably think of some principles that are unwritten, but that work. So what are the limits of legal research? Is what I have just told you a myth, and the legal research beats everything? Or are there indeed some unwritten aspects of our legal system?
Well, that's a massive and complex question. But let me take a stab at it from my background, from my PhD dissertation, which was about rhetoric. Now, rhetoric is about persuasion, and what the legal profession is about, and what judges are about, is about persuasion. And Aristotle wrote that persuasion takes place in three forms. One of them is in politics, one of them is in sort of ceremonial occasions, and the other one is judicially. The law is an aspect of persuasion, and but what Aristotle and others back 2,000 or 3,000 years ago taught, they were the originals of law schools, and the sort of notion of the legal profession actually begins back in ancient Greece, and there would be parallels across the world. Aristotle's theory, which is the one that I think works, is that there's three kinds of persuasion. One kind of persuasion is what he called logos, that's legal, logical, a set of rules, a set of principles, a set of arguments that use. That's the paramount one. But along with it, he said there was ethos and pathos. Ethos is the character of the speaker, and it's their testimonial and personal authority and weight. And a good lawyer will have ethos. They in themselves will be persuasive in the manner in which they carry themselves and the integrity in which they do so, and the trust that they can build up with the adjudicator, the person they're trying to persuade. And then there's pathos, and pathos is the appeal to the emotions. It's the fact side of it. It's the justice side of it. It's the where it grabs you in your gut. They all work together. Now, a good lawyer and a good judge understands how to work all of those buttons. I think all of those buttons are important, and a lawyer will know how to tell the story and push the buttons, but the lawyer will still have to make that all fit within something that's logical and legal. We don't and cannot rule just, by the heart. But those factors work. If there's lawyers that we trust, then they tend to be more persuasive. But you can only push it so far, because you know that at the end of the day, you're only as good as your horse you're riding. And you can't, you can ride it as hard as you can, but lawyers lose more cases than they win. It's not necessarily their fault. I consider myself in the same business of persuasion. I have to persuade the parties and the Court of Appeal from time to time, or the divisional court, that the judgment, the decision was sound. But it's all about persuasion, and all of that works. I think there is interesting work to be done about the the emotive side, and how you stir up a judge one way or another. And there's interesting psychology that goes into that. Aristotle's book on rhetoric was regarded as the first book on psychology. So I think that might be helpful for you to sort it out, but I would say that you can't ever abandon the law side of it. And so it sets parameters, but you can't just put all your, you just can't rely only on the law. You have to rely on the whole package to make it work.
So I'm particularly curious about the pathos element of rhetoric. The logos element, I guess, is what they teach in law schools, or try to teach in law schools. That's legal research, reading the law, writing the law, the tests, the legal tests that we find in cases, in case law. That's the logos element. I understand the ethos element. I understand the credibility of the lawyer. I talked about that with some previous guests of the show. It's a reality, some lawyers have more credibility, period. And it's not anybody's fault. It's just that this lawyer is more credible. He has earned it, or she has earned it. But the pathos element seems to be, to me, the most fascinating, because it seems to be a set of rules also, just like the logos element. It seems to consist of a set of rules, but those rules are not really written as neatly as the rules that go into the law itself. I'm very curious about the source of these unwritten rules, or at least the source of pathos, the source of the feeling of justice or the feeling of right and wrong that both lawyers and judges will experience, and then they know that they're doing the right thing. Is there Canadian pathos? Is it different by country? Is it different by city? Is it different by community? Is it different by case? What can you tell about that?
Well, first of all, there is actually quite a bit of writing about it. Some of it is intuitive, and some of it is scholarly and defined. Quite a bit of the intuitive side of it is actually in the legal writing about trial advocacy or appellate advocacy or persuasion, and can be taught and it can be acquired, about how you can push emotive buttons. Lawyers, I probably intuitively do too much of it, because they tend to focus on what is described as the color of the case, and they find the color of the case and they beat the color of the case, and they try and persuade the judge by the color of the case. They quite simply from time to time try and make you mad at one person or the other. There's a danger with respect to overdoing it, I think, because sometimes judges react to the bullying that goes on, or the disrespect that one party shows the other. But it's the color in the case, and people, lawyers learn how to play the color of the case, and they do it frequently. There is a natural intuition. People know how to argue, and people also can be trained to understand, what's a fallacious argument, or what's an ad hominem argument, or what is an argument towards the person as opposed to the principles of the case. All of that can be understood. There's a lot of scholarly work about persuasion. The advertising industry is built on persuasion. If you pick up some books about advertising, if you pick up some books about marketing, if you pick up some books about decision making, you'll get a ton of psychology about things that can persuade. There's not a lot of legal writing that takes it into the science. Todd Archibald in his book, has written quite a bit about the psychology of persuasion and things like that. Lawyers are not, they may acquire it by intuition. When you settle cases and when you're bargaining to do a settlement, you're pushing emotive buttons as much as anything else. Negotiation is another form of persuasion. There's a lot of psychology, with respect to that, that goes in to the process. If you wanted to be a student of it, you could be a student of it, and so it is written down, and you shouldn't undersell what your intuition about these things are. Lawyers tend to have pretty good intuition about how to push emotive buttons. You know, the
My
criminal lawyers know how to do it, and the civil lawyers know how to do it, and the family law lawyers know how to do it for sure.
Yes, yes. My last question is about the practical application of what we have just talked about for the last 15 or 20 minutes. There is a view that you often express your initial opinions about the case based on written materials alone. So in your practice, what is the effect of the written advocacy on you? Is it does it have the predominant effect? And then if not, or if yes, then what is the role of oral advocacy? Is oral advocacy where the pathos happens for the most part? What is the balance between the legal and, I'm sorry, the written and the oral submissions in your experience?
Well, it's changed over the years, and the current situation on the civil side, where most of the work now is being done remotely, just the way we're having our conversation right now, and there's much less in-court oral attendances. So we're at an interesting period of time to try and understand how oral advocacy is going to work out on the civil side. On the criminal side, they're going back by and large into the courtrooms. And the mix between oral advocacy and written advocacy, differs to a certain extent, well, to a large extent, depending on what line of service we're talking about, whether it's, the criminal, where there is a major tradition with respect to oral advocacy and criminal jury trials and a variety of other things. Most judges will tell you that the criminal law advocates are better oral advocates by far than the civil ones. They get more a chance to do it, they're better at it than the civil ones. Practically speaking, as you know, civil lawyers do way more writing than they get the opportunity to be in court, standing up on their feet during oral advocacy. We do, on the civil side and the class action side, a great deal of the thing is driven by the writing as opposed to the oral advocacy. I think another change has been the imposition of time limits. I mean, when I, at the start of my career, there were no time limits. A case took as long as it took to argue, and people had a sort of the time. I mean, I argued cases where, you would stand up and say, here's the case, here's the facts of the case, here's what the decision was made in the case, here's the academic commentary on the case, and here's where you want to take this case. You never hear that anymore. I mean, nobody's got any time, to do that. What you get now is, a cut and paste from one section of the case that nobody's ever talked about, or a reference saying you can read it in my factum. So we've outsourced a lot of the reading that used to be done orally, that's now done. Actually, it's not even done in the courtroom. To answer your question personally, I do a great deal of preparatory work before any motion is argued. And I try and understand the case, and I will usually have an inclination of where I'm leaning by the time the oral argument begins. I wonder from time to time whether anything has usefully been added by the oral argument, but often I find the oral argument to be very useful and an opportunity to better understand the case and to be fair in arriving at a judgment. So I'm not in the camp of saying that we should go and move to some sort of written world only, which would be which is kind of, we're trending towards that to a large degree. But I think we have to be careful that we don't abandon oral argument. And but I think people are going to have, my colleague Justice, Letterman, we've talked about this, and he's indicated that we're in a new world about oral argument done remotely. I mean, what's there's a different set of presentation skills that may need to be developed, and I can't tell you yet what's the best way to go about it, but it looks like we're not going back.
Right. Justice Perell, I want to thank you for your knowledge, for your experience, for your commitment, for your generosity. I want to thank you for this interview. I can't wait to share it with our audience. Thank you so much, Justice Perell.
Well, thank you very much for inviting me, and you were very kind in your interviewing, and so I appreciate it. Thank you, sir.